Hello friends, my name is Srinivas. My today's topic is section 245 of CrPC. When accused shall be discharged by a trial court or a magistrate court. When accused shall be discharged as per section 245. Clause 1 says when the magistrate takes evidence of the witnesses under 244 and there is no evidence or no case is made out against the accused as per 244 evidence, the court can discharge the accused. And as per the section, it is very much clear that 244 evidence has to be brought on record, then only 245 will be invoked by the trial court magistrate or judges. The magistrate under 245 clause 1, it says that if upon taking all the evidence under section 244, the magistrate consider for the reason to be recorded that no case against the accused is made out, the magistrate shall discharge him. And why the accused has to be discharged when evidence is brought on record? Prior to going through the trial aspect, the first point which is very much important is after issuing summons to the accused when he appears before the court and charge sheet is given to him, he will be examined with regard to the charges those are to be framed against him. If he denies those charges, then the trial will commence in a criminal trial court. After charges are framed, when the court will take evidence under 244, and then only 245 coming to can be invoked by the trial court. And the section is very much clear. Clause 1 says, after evidence is adduced by the prosecution and the case is not made out against the accused, then 245 CrPC, the accused can be discharged. So what are the grounds on which in a criminal trial either discharging the accused or framing of charges? Charges are very much important. Only after the charges are framed, he can be discharged as per or leading of evidence as per 245 CrPC, clause 1. The accused can only be discharged under section 240 when all the evidence in chief has been recorded by the trial court. And what next? Power of discharge not discretionary. As the court, when you court want to discharge a particular accused in a trial court under 245, it has to give a finding for the discharge. A speaking order should be there in the trial court. Only basing on a judicial speaking order only, the accused can be discharged from the said offence. And the court cannot, without judicial mind, can order for discharge. It has to go through the evidence that has been brought on record, and then only he can be discharged. That is the section 245 clause 1 says. And with regard to other point, the power under section is not discretionary power of the magistrate. It is exercised judicially as reasoning has to be brought on record. Without giving the reasoning by the trial court, the accused cannot be discharged. The court has to give reasoning why court is discharging the accused against the charges those are being framed against him in criminal trial. And then this is very much important, because unless and until charges are framed on record and the evidence is led by the prosecution, the 245 clause 1 cannot be invoked by the trial court or discharging of the accused. And the main point for which the discharge can be entertained or is discharge should pre-charge should be there. So earlier charges should be there, then only discharge can be entertained under 245 clause 1. And proceed in case where evidence discloses more offences. It sometimes happens that the charges will be framed for particular evidence, particular section of law, and during the course of trial or leading evidence, separate charges has to be brought on record, because new point will come into existence because of the leading evidence, and new sections has to be brought on record because of the evidence aspect. So at such time, the accused cannot be discharged from the case or from the charges or from the criminal case. Another thing is procedure where magistrate finds no jurisdiction. When the trial court comes to a conclusion that when the charges are being framed and the evidence is led, it comes to the knowledge of the court that this particular case could not be tried by him because lack of jurisdiction. Immediately it has to transfer that case to the particular court where the jurisdiction to try such a case is there after going through the evidence part. And that is the very much important with regard to trial court. Another is proper order in case of joinder of summons and warrant cases. When a case is such that it is a joinder of charges has to be made, like it will be a warrant case and summons case. So one of the thing has to be looked into and a trial has to be conducted as per the warrant case, and summary trial cannot be conducted in that particular case. So summary trial has to be considered as if it is discharged to that extent. And when a court is framing charges, in the charge sheet there may be several sections which were being brought on record by the prosecution. During the course of framing charges and the evidence led or going through the charge sheet or evidence, the court finds that certain sections cannot be invoked or cannot be give any finding to that effect because there is nothing on record which was been brought by leading the evidence. So that particular section they will not give any finding by the trial court. So when they will not give any finding to any particular section, it will be deemed as if those sections are being, the accused is discharged to those particular sections where charges are not framed against him for those particular sections. And for the remaining sections which were being evidence led and charges are framed, those sections are deemed as if trial has to be considered. And remaining section of for which the court has not given any charges, not framed any charges, those are to be deemed as is discharge of those offences or sections. That is the trial. And another is withdrawal of complaint from prosecution. Sometimes it so happens the prosecution case want to lead the case, but the complainant don't want to pursue the case, and he want to don't want to pursue the case. He don't want to continue with the case. At this juncture, the court can discharge the accused because complainant don't want to press the case and there is no case as if to be charged or no case is made out against the accused. So he can be discharged basing on the complainant's non-appearance or is not prosecuting the case. Another discharge respect to offence not specified in complaint legal. When certain sections will be not there in the complaint, and even trial court after going through the complaint or the evidence and everything, where it finds that no case sections are there or no case is made out, specific offence is not there in the complaint, the person can be discharged from the such charges or crime cases. And what are the proper grounds for discharging a particular person? And these are several points on which the court can consider to discharge the accused. Discharge the proper when prosecution vitiated for want of sanction. Sometimes a case will be such that a sanction is very much necessary. Like if we will go through the trial of some of the cases where the public servant has supposed to be prosecuted by the complainant. If sanction is not obtained by the government, or sanction is very much necessary as per 197 CrPC, and without that we cannot prosecute the person, and if the prosecution agency does not obtain any sanction to prosecute that particular accused, it will be fatal on the part of the prosecution. Then that is one of the grounds for discharging the accused by the trial court. Another, discharge proper when complainant person keeps. Sometimes when a complainant will file a complaint and he will proceed with the case, and due to some reason he don't want to pursue the matter and don't want to appear in the case, or he intentionally neglects to appear before the court and don't want to pursue the court case, then the court can discharge him in such a ground. That is one of the grounds, second ground. And third ground is discharging proper when evidence default. So it's sometimes happen that the ground on which the case has been made out and led by the prosecution, and in the trial or somewhere the section is not been proved by the prosecution through evidence or through documentary evidence, whatever it is, the person can be discharged by the trial court under 245 sub clause 1. These are the grounds on which discharge point can be taken in. And what are the not proper ground for discharge? When discharge should not be entertained by the trial court. There are grounds for discharging the accused. As per earlier I told you, those are the points where court can discharge a particular accused. And there are other points where court even should not entertain petition or accused should not be discharged. Those grounds are that prosecution not producing material witnesses examined in preliminary inquiry. Sometimes the prosecution will fail to produce the evidence or witnesses at the time of preliminary inquiry. So that is not the ground for which the court can discharge the accused, because sometimes at the time of preliminary inquiry certain people will not appear as a witness or they will not appear. Subsequently, during the course of trial, before the trial court, they will appear to give evidence and to make their statement. So this is not the ground where court can discharge the accused, because preliminary inquiry certain evidence were not been brought on record and he should be discharged from that particular offence. That could not be done by the court. Second point is illegal arrest does not justify discharge. And criminals or the persons, sometimes they will be arrested with regard to certain offences, and because they were arrested and it was illegal, that doesn't mean that he should be discharged from the offence against the charges. Sometimes they will be arrested and there may be reason that they may be legally arrested, but because those people are illegally arrested, they cannot plead for ground for discharge saying that he was been illegally arrested, so he should be discharged by the trial court. That cannot be done by the trial court or the counsel on record. Discharge where not proper on absence of complainant. Sometimes the complainant will file a complaint and due to some reason, due to health reason or some other reason, he cannot appear before the court for leading evidence. So this is not the only point on which the discharge can be entertained or the accused can be discharged from the charges leveled against him. And the complainant, because he is not appearing before the court, the accused cannot be discharged. And with the remaining evidence also, the court can proceed with the trial and can give finding on that particular offence. And another is prima facie case. When a prima facie case is made out against the accused by leading evidence and going through the material objects and the documents which have been marked by the court, after going through all these things, if a case is made out, the court cannot discharge that particular accused, because already evidence is on record and document evidence is there and material objects are there. All things are being marked by the court, and the prosecution tries its best to convince the court through all these that the charge is made out against the accused and he should be convicted. The court cannot discharge that particular accused at this stage. And no deliberate delay. When there is no deliberate delay on the prosecution side, because of some reason, sometimes it so happen that the witnesses will not appear before the court due to their personal reasons. So because they are not coming before the court and there is a delay of trial or adjournments going on and all, because of these reasons, the accused cannot be discharged by the trial court. This is one of the point. And now comes with regard to what amounts to discharge. In a criminal case, what amounts to discharge, whether it is acquittal or simply discharge. Sometimes after going through the evidence, the court will give a finding saying that he is acquitted from the charge. Whether discharge, what amounts, that says it's a discharge, not acquittal. Release of accused without framing of charges. When accused is being released without framing of charges due to some reason by the trial court, that does not mean it's acquittal, and it's simply a discharge. Dismissal of non-compoundable warrant case amounts to discharge. A non-compoundable warrant case, when it is discharged due to some reason, the accused will be treated as discharge. When a non-compoundable offence is closed by the trial court, it will be deemed as if it's a discharge of the accused. And sometimes even after the warrant has been issued, in a warrant case, termination proceeding of issuance warrant amounts to discharge. Termination of proceeding after issuance of warrant. When a warrant is issued against the accused and a court want to discharge him because of some reason, a court has terminated the proceeding itself by some order or some going through the record or whatever it is, it will be treated as a discharge only. These are one of the reason. And moreover, the court, when it want to discharge certain accused from the charges, like several accused will be there and cases are being when you will go through the records like evidence part and documentary part, other issues, when court finds that there is nothing mentioned with regard to certain accused in that particular case, the accused against whom no evidence has been led by the trial by the prosecution, or no records has been marked against them, and no facts have been brought on trial record before the court, then court can discharge those accused. And remaining accused, the case will proceed as if the case is under the trial. So for remaining accused, the case will be a continuation, but against the accused, some of the accused against whom the evidence is not led and nothing has been brought on record, nothing is part of the record, then they can be discharged by the trial court. But to that effect, the court has to give a speaking order in its finding for discharging the accused as per section 245 clause 1 and so 245 clause 2. Without speaking order, there will be no discharge. That is contemplated under the CrPC and the judgments, certain judgments. These are the points very much important in with regard to discharge of any accused under section 245 clause 1 and 245 clause 2. And one of the word is the word at any previous stage of the case is a stage after recording of some evidence. So in this particular section 245 clause 1, it says previous stage of the case. That is the point which was been there in 245 CrPC section. So with regard to coming to what is actually previous stage of the case, it is the word at any previous stage of the case is the stage after recording of the some evidence. It is neither a stage before recording of any evidence at all, nor stage after recording of entire evidence. So certain evidence has to be led by the trial court. That is very much clear with regard to this word which says previous stage of the case in a trial. Magistrate cannot draw proceeding against some of the accused person, particularly after taking cognizance. As I told you just now that some of the accused can be dropped from the charges after charges and they can be discharged. But when once the cognizance has been taken by the trial court, and the magistrate cannot draw proceeding against some of the accused. It is a judgment of 1968 to Mysore Law Journal 604. So these points very much important with regard to discharge of accused under section 245 clause 1 and 2 of CrPC. Thank you very much for watching this video. This video was very much concerned with regard to discharge of any accused after evidence has been led by the prosecution and some of the evidence has been brought on record by the trial court. At that stage, the court can entertain discharge of accused by going through the evidence part, and when and how, what is the procedure that has to be followed, whether speaking order should be there while discharging. These are the point very much under the pursuance of 245 clause 1 and 2 CrPC. Those things are supposed to be considered by the trial court, which is very much important. The accused can only be discharged under 245 when all the evidence in chief has been taken on record. This is the CrPC which speaks about these things. Friends, my name is Anil Srinivas Akula, advocate. Whatever I just now told you about in this video, I have gone through different journals and CrPC books. After going through all these things, I gave you my version, or what you can say, I spoke on this particular subject. Thank you very much for watching this video.